other strategies to avoid the estate tax or minimize, okay? Strategies to reduce or avoid estate tax, okay? We talked a little bit about gifts, okay? And listen up for the single people, because single people do not have the benefit of putting estate tax planning language in your revocable trust, but single people can still engage in gifting strategies in their lifetime, okay? So I had a case a couple of years ago. A friend of mine's dear mom, she was a widow, her husband passed away, and she had an estate greater than $1 million. And in her situation, her health was declining, she was home on hospice, and she had an estate about $1.6 million. And if the family didn't take any action, they would have been paying maybe about $80,000 or $90,000, from my understanding, to the taxing authority here in the Commonwealth. But what the family did, they engaged with their accountant and their financial people, and we assisted them also make sure the T's are crossed and the I's are dotted. And before the person passed away, they were able to permissibly gift out of their estate over $600,000 to reduce their taxable estate from 1.6 below the $1 million threshold, making gifts to their children and their grandchildren. They crossed the T's, dotted the I's, made sure they did things permissibly and appropriately, and that way that money went to their loved ones, their why, and not to the tax man, okay? So really, really important. So in that situation, if you're an individual and you're not married and you don't have the proper estate tax language in your trust, there's still things you can do, okay? So you can make gifts. Again, gifting is a double-edged sword because the timing of the gifts is everything. If you make gifts to reduce your size of your estate, I'm going to give you a big caveat, a big warning, big disclaimer, big warning. If you do that, and then later, within the next 5 years, if you're looking to get on Medicaid benefits, Medicaid, when you're filling out a Medicaid application, Medicaid has a right to look at 5 years of your financial records. That's why I call it a double-edged sword. You might be avoiding getting bit by the second-headed monster, reducing the estate tax, but guess what? A year later, you have a stroke, you have a catastrophic accident or illness, and now you need to go into the $15,000 per month nursing home, and you're looking to get on Medicaid. Medicaid has a right to review all your financial records going back 5 years, okay? So now they're reviewing your bank accounts, and they see that you're giving all kinds of gifts away to your children and grandchildren. That's going to create what they call penalty period. They're going to say, you were sheltering assets. If you didn't give all that money away to your family, you would have private pay cash to pay for your nursing home. So we can't give you government money because you gave all your money away. So that's 5 years. So if you're going to give gifts away, my advice to folks is you typically do that when you're a little bit younger and alive and well, and you don't want to be doing that in the fourth quarter of life or 2-minute warning, because in my opinion, from my experience, you're taking a lot of risk, because if the shoe drops within that 5-year period of making gifts and you need to get on government Medicaid benefits to pay for your long-term care, you might be out of luck because it'll create that penalty period. Only way to cure a penalty period typically is for the recipients of that gift to repay the money, put that money back into your account. And also from my experience, usually that's not the case, not that easy. Why? Because the money's no longer there. Money's no longer there. The children and the grandchildren already use it for bills, tuition, they might have bought an automobile, might have bought a house, or whatever it may be. The money's usually not there, usually puts a tremendous strain on family relations because another family member typically has to come forward, bail them out, and that usually doesn't bode well for family relations. So be very, very careful when making gifts. Again, it's not a do-it-yourselfer project. You want to work with your qualified financial team, tax team, and your return legal team, okay? Collaborate, work with a collaborative team before making any gifts. It's a serious matter. You want to make sure you do it permissibly and correctly, okay? Can't stress that enough. All right, so gifts is one way to reduce or avoid the estate tax. I just gave you an example of how that was done, okay? How much can you gift? We talked a little bit about that on the current tax code. You can gift as much as $15,000. The donor is the person giving the gift. The donee is the recipient, okay? So you're giving money to, say, one of your children. You can gift up to $15,000 any calendar year, January until December 31st. That's considered a calendar year, $15,000. If you exceed, there's a legal requirement to file that 709 gift tax return, okay? Everybody under current law has a lifetime gift tax exemption of 11.58 million indexed for inflation. And this is the year 2020. That number is scheduled to go up next year, but scheduled to sunset in the year 2025, back down to 5 million, okay? That 11.58 million is scheduled to go back down to 5 million. And again, it's an election year. Depending on who takes over the White House and Congress, that can all change. It changes every year, or every few years, I should say. Or every administration is pretty consistent that the estate tax typically changes. So it's something you need to monitor and keep your eye on. So you can gift away $15,000 donor to donee, okay? And you can give as many gifts to as many people as you want. They don't even have to be family members, okay? So if you have 5 kids, take 15,000 times 5, all right? During that calendar year. So you're the donor, you can give up to $15,000 per donee. And you can give as much money to different donees. They don't even have to be family members. The key is, if you exceed $15,000 to any individual donee, you have to file that 709 gift tax return, okay? That being said, there's a thing called a split gift for married couples. And that means you can double that $15,000 to $30,000, okay? So if Bill and Mary want to give their son Mo a gift, they can give him more than 15. They can utilize what they call a split gift and give Mo $30,000. If Mo is married to Mary, they can double that by giving each Mo and their daughter-in-law $30,000, or a double split gift of $60,000. Okay? That being said, if there's a crisis situation and you're well over $1 million and you need to catch up and you're on hospice and you don't have a lot of time left and you don't have to worry about the fourth-headed monster because you're not going into a nursing home. You're checking out. Mother Teresa's waiting for you. St. Peter's waiting for you at the pearly gates. And your doctors gave you a diagnosis that you have borrowed time. Could be days, could be hours, could be weeks. That's a time that you want to work with your qualified team of professionals, your tax professional, your financial professional, your legal professional. Have them work together as a team to assess and evaluate your situation. And if it is permissible, you may be able to make gifts in excess of the $15,000 and utilize your lifetime exemption. Utilize that lifetime exemption, whatever it may be, on that current tax year. Once you exceed $15,000, there's a legal requirement to file that 709 return. But that's okay. That's okay. You still may not owe any estate tax because you're utilizing the ceiling, whatever the lifetime gift tax exemption amount is. And just to refresh your memory, typically the lifetime gift tax exemption amount is equal to what? The federal estate tax amount, right? They're usually the same number. So if they go up one year, they go down another year, they're usually consistent, usually the same number. The key here to remember, folks, is gifting is a way to minimize your estate. Don't forget the double-edged sword, gifting and needing Medicaid benefits within 5 years. The double-edged sword. You can go to my website, elderlawcare.com. I did an article and a blog on that a couple of years ago. But I used a fictitious character who gave away money. She liked to give money away to her children and grandchildren, which is a common thing. And that makes her feel good. That makes her feel good. But you got to be very, very careful because it might make you feel good, but if the shoe drops for you and you run out of money and you need to get on government benefits to pay for the nursing home, to pay for your long-term care, you're not going to get the Medicaid benefits within 5 years of making that gift because they're going to construe it as you were sheltering money and it's going to create that penalty period. So be very, very careful. Again, this is not a do-it-yourself project. Work with your qualified professionals before acting, okay? Really important, folks. All right, folks, other ways to spend down your estate outside the estate tax planning language we talked about, the credit, shelter, trust, outside making gifts, charitable bequest, okay? Some clients will come to me and say, hey, Patrick, I don't have a spouse, I don't have any children, I have nieces and nephews, but really not close to them. But I do have some things that are really close to my heart. I have school or a hospital or a university or some type of organization, a veterans organization or a post, or some type of charitable organization. It could be the American Heart Association or the Lung Association, whatever it might be near and dear to your heart. And that's called a charitable bequest. So if you have a $2 million estate here in the Commonwealth and you gift over $1 million to the charity of your choice, that's going to get you below the $1 million threshold. So you may not have a taxable estate for the estate death tax. So think about that. Again, work with a qualified attorney when putting that plan in place. There's certain things that need to be done within the plan, within the trust, to make a charitable bequest. There's different types of charitable trust as well that can be created to help you with your cause when you're making that charitable bequest, okay? So think about charities as a way to lower your estate. Think about charities a way to not get bit by the second-headed monster, which is the estate death tax. Folks, moving on. ILETs. What is an ILET? That is an acronym for Irrevocable Life Insurance Trust, okay? Acronym for Irrevocable Life Insurance Trust. These ILETs used to be a big planning tool back in the mid-90s when the federal estate tax was at about $650,000. So every family practically across America was getting hit with a federal estate tax at about 40%, or a real high number. So it really made a lot of sense for folks to create ILETs, Irrevocable Life Insurance Trust. It still makes sense for a lot of my clients who live here in the Commonwealth, Massachusetts, when they have a large life insurance policy, $250,000, $500,000, $1 million worth of term life insurance. That's going to get added into your gross estate for the state estate tax or the federal estate tax calculations, okay? So an ILET is a way to get that asset out of your name, out of your estate for taxable purposes, okay? So this is how it typically works. It's a trust called an ILET. And if you have, say, $500,000, $250,000, $1 million life insurance policy, pick your number. We'll say $1 million term life insurance. And say you have an estate worth $1 million of other assets, home, 401k, IRA, cash. You got $1 million there. So you just have the threshold of $1 million estate tax. Then you have $1 million in life insurance. That doubles your estate. Now you clearly have a taxable estate here in the Commonwealth. You're at $2 million. The estate tax threshold is at $1 million. Okay, that's tens of thousands of dollars. Estimated probably about $150,000 maybe owed to the tax man. And that's just an estimate but it's a lot of money owed to the tax man if you don't take action. But say you create an irrevocable life insurance trust. You put that $1 million into the irrevocable life insurance trust. You are no longer the owner because the trust owns the life insurance. The key is, folks, there's a 3-year look-back period on existing policies. So if you have an existing life insurance policy and you pop it into your ILET, you don't have that exemption from your estate for a 3-year look-back period. Why? Because the Internal Revenue Code doesn't want people making deathbed transfers, okay? So they do not want people making deathbed transfers. So the 3-year look-back period on existing policies. However, my understanding, if it's a new policy that you're purchasing, okay, you can pop that right into your ILET day one, and you should get that protection day one outside your estate. So in that case right here, if Bill had a $2 million estate, house, retirement in cash, $1 million, $1 million in term life, a whole life, take your pick, $2 million estate total, he can reduce his estate by putting the $1 million life insurance into the ILET to get that out of his estate, because his position is, I no longer have incidence of ownership over that policy. My trust owns the policy, okay? All right, so that's how that type of planning works, folks. Really a nice strategy to utilize when you have a lot of life insurance, or even if you have a moderate life insurance policy that puts you over that $1 million threshold. So work with your qualified estate elder law attorney and explore creating an irrevocable life insurance trust to minimize your estate tax, okay? Or avoid it in some cases altogether. All right, folks. So we talked a lot about taxes here. We talked about different types of taxes. We talked about ways to reduce the taxes from putting bypass tax credit sheltered trust language in here. I want to mention something also that's important. When you're creating a bypass trust, it's also oftentimes important to create what they call a QTIP. Again, that's an acronym for Qualified Terminable Interest Property Trust. That's a certain type of trust language provision that we put into our client's trust to make sure their assets in their bypass trust get the stepped up in basis on that asset. Kind of getting deeper, a little more complex into tax language here, but it's important for me to mention or reference a QTIP built within the bypass tax credit sheltered trust. That's one way of planning for married couples to reduce or avoid the estate tax. We talked also about gifting strategies. We talked about charitable bequest to a charity of your choice to reduce or avoid estate tax. And then we talked about ILETs as well. Okay, again, folks, these are all very strategic ways of reducing or avoiding estate tax. None of them are do-it-yourselfers. Work with qualified professionals before leaping. Okay, really, really important. Can't stress that enough. Work with a qualified estate attorney, elder law attorney, estate plan attorney, qualified CPA accountant, and or your financial advisor collaboratively together. All right? Don't cut any corners here because it could come back to bite you in the wallet. You don't want that to happen. Okay, we're going to talk about the third-headed monster of estate planning in elder law. What is the third-headed monster of estate planning in elder law? That's financial creditors and predators. A lot of our clients will say, hey, Patrick, we worked really hard for what we have. How can we protect our 3 children? We love them all dearly. Their names are Mo, Larry, and Curly, okay? We love our children, but we want to protect them, and how can we do that? From my experience, folks, most estate plans that I review, whether it's a will or a trust, make a distribution in the palm of hands of Mo, Larry, and Curly. Bill and Mary are giving them a gift, but the problem on the downside to that, from my experience, it is not a protected gift. So if Mo, Larry, and Curly are going through what I call times of turmoil, whether it be an automobile accident, a divorce, a bankruptcy, lawsuit, any poor decisions, if they, what we call hit the hit parade, alcohol, drugs, maybe there's a mental illness, you really have to have the proper language in the trust center plan to make sure that their inheritance is properly protected from financial creditors and predators. So let's talk a little bit about that. So financial creditors and predators could be lawsuits, auto accidents, divorces, in-laws becoming outlaws, bankruptcies, any times of turmoil. Take your pick. Okay, what else? Times of turmoil, lawsuits, automobile accidents, divorces, bankruptcies, in-laws becoming outlaws, times of turmoil, casserole brigade. You'll learn in a few moments what the casserole brigade is all about. And who's the leader of the casserole brigade? It's Betty the barmaid. And Bo the tennis pro. Okay. All right, folks. Let's talk about lawsuits, automobile accidents, divorces, and bankruptcies. So most wills will have language in there where mom and dad are gone, everybody gets everything, free of trust. The problem with that, it exposes how much of their inheritance to creditors. How much? That's right. 100% is exposed to creditors. Because if the asset is being distributed to you, whether it's in a will or in a lot of trusts that I review, free of trust, free from trust, there's no asset protection in there. You are the individual owner. If Mo, Larry, and Curly Even if their parents had a modest estate of $300,000, they're all getting $100,000 each. In the palm of their hands. They encounter any of this, lawsuits, auto accidents, divorces, bankruptcies, any times of turmoil, all that money, 100% of their inheritance is exposed to their creditors. So the devil's truly in the details, folks, when you're creating asset protection, okay? So typically, the language we put into our trust is what I refer to as family bloodline protection trust. Family bloodline protection trust. It's not an outright distribution in the palm of hands of Mo, Larry, and Curly. Their parents didn't want to give that gift to them. They wanted to give them something better than a gift. Again, they wanted to give them a protected gift. And from my experience, there's no downside to creating a protected gift for their children, okay? You're giving them their cake and eat it too, so to speak, all right? So you can create these family bloodline protection trust, FBPT, within your trust. So you're not giving that outright distribution in the palm of Mo, Larry, and Curly's hands. What you're doing is you're creating subtrust within your trust, okay? So let's give you an example. Here's Mo. Mo has his family bloodline protection trust, okay? He gets his $100,000. Mo can be the trustee manager of his own trust share. Who's the trustee manager? Managing the money? It could be Mo. Who's the beneficiary? Mo. Mo is also the beneficiary of his own trust share. So this is a game changer, folks, and I'll explain how it works. So Mo now has a family bloodline protection trust. His parents, Bill and Mary, check out. Bill and Mary Howard. They give Mo $100,000. Mo has his $100,000. It's not in the palm of his hands. It gets payable to Mo in his bloodline trust. He's a trustee manager. He's in charge of his own money, but he has discretion to make distributions as a trustee manager to himself as beneficiary, okay? Some folks refer to the family bloodline protection trust as a discretionary trust, okay? So the trustee has discretion. And the discretionary language that we typically put in these trusts is called ascertainable standards. Ascertainable standards, or HEMS, okay? HEMS stands for health, education, maintenance, and support. So this is a true and tried Internal Revenue Code language that's permissible to put into a trust to provide some level of asset protection. Is it bulletproof? Absolutely not. Does it greatly enhance the asset protection? It does. So it's a nice sweater to have in the suitcase. And this is how it typically would work from my experience. If Mo is encountering any of these times of turmoil after his parents pass away, his position or his attorney's position to the financial creditors and predators is this. Hey, look it, Mo did not have an outright distribution of $100,000 or $1 million, whatever it was, in a simple will. Mo didn't have the problematic 3 words, like I review in a lot of trust. Mo gets everything free of trust or free from trust, which is an outright distribution in the palm of his hands. If that were the case, Mo is the 100% owner individually. He would take that $100,000 or say it's $1 million. He would deposit that in his individual bank account. Folks, as you may have learned, asset titling is one of the most important things in estate planning. So now if Mo gets into times of turmoil, it's easier for a creditor's attorney, a judge, or a jury to make a decision and say, hey, Mo, you own that money 100% individually in the palm of your hands. You can easily pick up the pen and write a check to the creditors and the people who are hurt in that automobile accident or a catastrophic automobile accident like a school bus accident. We have many creditors coming out of the woodwork, plaintiffs with injuries and lost wages and pain and suffering and all that stuff. And so if that money's payable to Mo individually, a judge or a jury, traditionally, historically, likely will theoretically say, write the check to the creditors in that situation. Game changer with the family bloodline trust. And this is how it works. Mo is a trustee manager. A trustee, folks, under trust law, has what they call the highest fiduciary duty of loyalty to manage the money in the trust for the benefit of whom? The beneficiary. Who's the beneficiary? Mo. So Mo, it's okay for Mo to wear two hats in his capacity as trustee, the fiduciary managing the money, as well as beneficiary receiving the money. So that's how it works. Mo can be the trustee of his own trust share and also make distributions to himself as beneficiary, but it's not an outright distribution in the palm of his hands. Hence the reason why some folks call it a discretionary trust. Mo can make distributions for health, education, maintenance, and support. So he can make distributions for, he needs money for groceries, he needs money for rent, he needs money for a mortgage, he wants to go on vacation, he wants to pay for education, he wants to pay for his children's education. That's what the ascertainable standards are: health, education, maintenance, and support. So the position of Mo's attorney is to the creditor's attorneys, hey, look at, Mo does not receive that money in the palm of his hands. Mo is a trustee manager of a trust, family bloodline trust or discretionary trust. He has a fiduciary duty of loyalty to manage that money for the benefit of the beneficiary. And there's been case law that supports the asset protection that's been created in that trust. So that's how family bloodline protection sub-trust work. Again, hopefully it never happens, but I like to call it a nice sweater in the suitcase. A nice sweater in the suitcase to have should the shoe drop with financial creditors and predators, okay? So folks, want to tell you a story about the Casserole Brigade right here. So my Florida colleagues refer to folks down in Florida as the Casserole Brigade. So had a case a couple of years ago, no names of course, a gentleman in this area, retired, moved to Florida. He was divorced and he remarried. And he remarried a woman which is commonly younger than him, okay? This man owned a lot of properties. He had a sizable estate, but the problem was he had the quintessential $500 will. And the end result was his $500 will unfortunately gave him and his loved ones about $500 worth of protection when he had a multi-million-dollar estate. So when he moved to Florida, along comes the Casserole Brigade. So typically, from my experience, there's one man living on the cul-de-sac down there in the community, and there's about 10 women to every man. So here comes the woman with their mac and cheese, or lobster mac and cheese, chicken palm, and meatloaf, and they're courting the man, bringing all the food over to him, trying to get to his heart and his stomach. And so typically, the man is going to marry whom? The best chef, right? And so who was the best chef in this story here? It was Betty the barmaid. So this gentleman ended up remarrying, and we refer to her as Betty the barmaid, and Betty the barmaid is the new spouse, okay? And they loved each other. The gentleman created a will-centered plan, and who did he name as 100% beneficiary of his entire estate? That is correct. He named Betty the barmaid, as his beneficiary, okay? A few years later, the gentleman checked out. St. Peter called. He went to the pearly gates. When he died, Betty got an outright distribution in the palm of her hands of his entire estate, okay? All his properties. What do you think Betty did after he passed away? That's correct. Betty went back to her attorney, and what did Betty do? What did Betty have drawn up? She had drawn up her own will, revoking the prior will, okay? And she had a husband and wife will with her husband. She revoked the prior will that she created, and she created a new will. Who do you think she named as beneficiary in her new will? That's correct. She named her children. So that's a case where all the assets went outside the family bloodline. All the assets went outside the family bloodline. A few years later, Mother Teresa called, and Betty went to the pearly gates, okay? And all the assets went to her children, unintended beneficiaries of her husband. And so in that case, the son of the husband was my client. He came to me and said, hey, Patrick, my dad passed a couple of years ago. My stepmom recently passed. I've been trying to get in touch with a Florida attorney to no avail. I drafted a letter to the Florida attorney, who promptly responded and kindly told me in the most respectful way that her client created a new will after her husband passed away, and that her client named in her new will all of her children as the beneficiaries. Sad news, I had to break that news to my client. So I explained to him, the good news is that your dad loved you. Your dad had you named as contingent beneficiary in his will. But your dad probably never fathomed in 1,000 years that his new bride, Betty, would ever change the provisions in the will. He probably never thought that she would cancel his will or cancel her will and create a new will and leave everything to her children. And so the important thing here, folks, is if you're concerned about that, or if you're in a second marriage, it's really, really important to put proper asset protection in your trust-centered plan. So in that case, if we could rewind the clock a little bit, do a rewind or do a do-over, it would have been really prudent and wise for that gentleman to have worked with a qualified estate elder law attorney who created a more comprehensive plan and put asset protection language in there to protect from the third-headed monster of estate planning in elder law. They could have put some family bloodline protection subtrust in there. So when the husband passed away early and the wife was the beneficiary, there could have been a provision in there that provided for the wife for the rest of her years. But put down lockdown language in there when she passed away that the beneficiary would be the original beneficiary, the husband's child, his son. So that could have been a completely different scenario if that gentleman had received some proper counseling, some proper information, some proper education, okay? Really, really important. Again, folks, this is not a do-it-yourselfer type project. Make sure you work with a qualified estate planning and elder law attorney who's familiar with this type of asset protection language to put into your suitcase or your treasure chest or your trust. Really, really important, okay? Again, hopefully it never happens, but it's a big price to pay. That poor gentleman's $500 will truly gave him about $500 worth of protection, okay? The good news, again, I could tell my client, your dad loved you, but the bad news was you're not getting anything from the estate. He lost everything, unfortunately. So that's a casserole brigade. That's Betty the barmaid, okay? But my clients are also worried. My woman clients say, hey, Patrick, what if I die first? What if I go first? And a woman told me a story once. She said her friend passed away with cancer in her 50s. The husband moved to Florida, and he moved into the cul-de-sac. And guess what? Who visited him? The casserole brigade, another story. And the husband remarried. So in that situation, they're all concerned about Betty the barmaid. But gentlemen, we also have you covered, okay? So what if you do what you're told? Statistically, the actuarial data says most men die first. My dad checked out first. He was older than my mom. And if the gentleman dies first, you want your wife to be happy, right? You want her to continue in life and have joy, and you want her to have companionship, but you may not want to share your treasure chest with the new guy, Bo the tennis pro, right? So along comes Bo the tennis pro. Bo the tennis pro is what they consider a financial predator. Bo the tennis pro is someone where your wife is mourning your loss. She wants to get out of the house. She joins the local Y, and she takes tennis lessons that she always wanted to take. And she goes down to the Y, she's taking the tennis lessons, and along comes Bo the tennis pro, who's the financial predator. Bo understands that he can marry your bride, be married for a short period of time, maybe 6 months, and then file for divorce. And he can make a claim towards 50% of the estate assets. So the solution there, folks, put remarriage protection into your plan. Prenuptial agreement requirements into your plan. That's another permissible way to create and provide asset protection. Again, hopefully it never happens, but it's a nice, big, warm sweater to have in your suitcase. Really, really important. And again, there's a lot of second marriages, third marriages, and sometimes more, multiple marriages. So really, really important. If you want to ensure that you're getting the front side of the cloud and you're realizing your dream snapshot, and you want to ensure beyond your control that the assets are going to the family bloodline and not outside the bloodline to casserole brigade, Betty the barmaid, Bo the tennis pro. You want to make sure you put family bloodline protection trust language in your trust. Also, make sure you work with a qualified attorney who can assist you in creating and designing and drafting your plan. Really, really important. All right, folks, so looking here, Family Bloodline Protection Trust, we talked about Betty the Barmaid, Casserole Brigade, Boda Tennis Pro, and there you have it, folks. Again, can't stress enough, work with a qualified estate elder law attorney who's familiar with this level of asset protection. Thanks for being here. We'll see you in part 3 of our program. I applaud you, folks. You're doing great, students here, and you're taking that personal responsibility by getting educated, getting informed, becoming that informed consumer by receiving this foundational education in estate planning and elder law. Hang in there, review your notes, look at your deadline that we talked about and your why. Make sure you look at your why. Make sure you write your deadline down within 30 days that you're going to take action with all this information that you've been learning. And I applaud you. Give yourself a pat on the back. Give yourself a golf clap because you're taking action. You're leading the charge. You're creating your legacy by protecting, preserving, and passing down what you worked hard for the people you love the most. Look forward to seeing you in part 3 of our 3-part webinar, How to Protect What You Worked Hard For from the Four-Headed Monster. Thank you for being here at elderlawcare.com. We'll see you next time.